Question 1. The audit findings indicate a potential discrepancy in the acquisition and disposition records for several firearms transferred by a federal firearms licensee, FFL, in California. The auditor has raised concerns about the completeness and accuracy of the documentation associated with these transfers. What is the most appropriate immediate course of action for the FFL? Option A. Rely solely on the auditor's initial assessment and proceed with corrective actions without independent verification of the flagged transactions. Option B. Immediately destroy or alter the records in question to align with the auditor's preliminary observations to avoid further complications. Option C. Conduct a detailed internal review of the specific firearm transactions flagged by the auditor, cross-referencing acquisition and disposition records with ATF Form 4473 and verifying all required information was collected and accurately recorded at the time of transfer. Option D. Dismiss the auditor's concerns, assuming the FFL's records are inherently accurate and no further investigation is warranted. Correct answer is C. Conduct a detailed internal review of the specific firearm transactions flagged by the auditor, cross-referencing acquisition and disposition records with ATF Form 4473 and verifying all required information was collected and accurately recorded at the time of transfer. Explanation. The audit findings indicate a potential violation of federal firearms regulations in California. This scenario is professionally challenging because it requires a nuanced understanding of the Gun Control Act of 1968, GCA, as amended, and its specific application to licensed dealers. The auditor's concern suggests a deviation from established record-keeping and transfer procedures, which could have significant legal and operational consequences for the federal firearms licensee, FFL. Careful judgment is required to determine the appropriate course of action to rectify any identified deficiencies and ensure future compliance. The best professional approach involves a thorough internal review of the specific transactions flagged by the auditor. This includes meticulously examining the acquisition and disposition records, A&D records, for the firearms in question, cross-referencing them with the corresponding ATF Form 4473, and verifying that all required information was collected and accurately recorded at the time of transfer. This approach is correct because it directly addresses the auditor's findings by seeking to understand the factual basis of the alleged noncompliance. It aligns with the regulatory requirement under 27 CFR Section 478, 125(e) to maintain accurate and complete records of all firearm transactions. By conducting this internal investigation, the FFL can identify any errors, omissions, or procedural breakdowns and then implement corrective actions, such as amending records or retraining staff, to ensure future adherence to the GCA. This proactive and fact-based approach demonstrates a commitment to compliance and minimizes the risk of further regulatory scrutiny. An incorrect approach would be to dismiss the auditor's findings without a thorough investigation, assuming the records are accurate. This fails to acknowledge the potential for errors in record keeping, which is a common area of noncompliance for FFLs. Ethically and regulatorily, FFLs have a duty to maintain accurate records as mandated by federal law. Ignoring potential issues leaves the FFL vulnerable to penalties and can indicate a lack of diligence in upholding their responsibilities. Another incorrect approach would be to immediately destroy or alter the records in question to match the auditor's expectations. This is a severe violation of federal law, specifically 18 U.S.C. Section 924(a)(1)(a), which prohibits making any false statement or representation with respect to the information required to be kept under the GCA. Such an action would not only fail to correct the underlying issue, but would also introduce new, more serious offenses, leading to severe penalties, including revocation of the FFL. A third incorrect approach would be to rely solely on the auditor's initial assessment without conducting an independent verification of the facts. While auditors provide valuable insights, their findings are often preliminary. A responsible FFL must verify the accuracy of the auditor's observations against their own records and established procedures before taking corrective action. This ensures that any remediation is targeted and appropriate, rather than based on potentially incomplete or misinterpreted information. The professional decision-making process for similar situations should involve a structured approach. First, understand the specific concerns raised by the audit. Second, conduct a thorough, fact-based internal investigation to verify the accuracy of the auditor's findings. Third, consult relevant regulations, in this case, the GCA and its implementing regulations, to understand the legal requirements. Fourth, if non-compliance is identified, develop and implement a corrective action plan that addresses the root cause. And finally, document all steps taken and communicate with the auditor or relevant regulatory body as appropriate. Question 2. Compliance review shows that a federal firearms licensee, FFL, in Texas is processing a firearm sale. During the background check, the National Instant Criminal Background Check System, NICS, returns a delay status for the potential buyer. What is the legally mandated course of action for the FFL holder in this specific situation? Option A. Proceed with the firearm transfer, as the delay likely indicates a minor administrative issue that does not prevent the sale. Option B. Immediately contact the National Instant Criminal Background Check System, NICS, to request a delay and await a final determination before proceeding with the transfer. Option C. Contact the local police department to inquire if they have any objections to the sale before completing the transfer. Option D. Complete the transfer if the buyer appears to be a law-abiding citizen and has no obvious signs of being a prohibited person. The correct answer is B. Immediately contact the National Instant Criminal Background Check System, NICS, to request a delay and await a final determination before proceeding with the transfer. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an FFL holder to balance the immediate need to secure a firearm with the legal obligations surrounding its transfer and the potential for a prohibited person to acquire it. Misinterpreting or misapplying the Brady Handgun Violence Prevention Act, Brady Act, can lead to severe penalties, including license revocation, fines, and even criminal charges. The FFL holder must exercise careful judgment to ensure compliance, while also acting responsibly to prevent firearms from falling into the wrong hands. Correct approach analysis. The best professional practice involves immediately contacting the National Instant Criminal Background Check System, NICS, to request a delay and await a final determination. This approach directly adheres to the requirements of the Brady Act, which mandates that an FFL holder must not transfer a firearm to a potential buyer if the NICS check results in a delay. The FFL holder is legally obligated to wait for NICS to either approve the transfer, deny it, or provide a unique ID number indicating the investigation is complete, which can take up to 3 business days, or longer if extended. This ensures that the transfer is only completed if the buyer is legally permitted to own a firearm, fulfilling the FFL's responsibility under federal law. Incorrect approaches analysis. Proceeding with the transfer after receiving a delay notification from NICS is a direct violation of the Brady Act. The delay signifies that the system requires further investigation into the buyer's eligibility, and completing the transfer under these circumstances bypasses the established federal safety protocols designed to prevent firearm sales to prohibited individuals. This failure constitutes a serious regulatory breach. Contacting the local police department for an opinion on whether to proceed with the transfer, rather than waiting for NICS, is also an incorrect approach. While local law enforcement may have valuable information, the Brady Act specifically designates NICS as the authority for background checks and transfer determinations. Relying on local police for a decision outside of the NICS process circumvents federal law and creates an inconsistent and potentially unlawful transfer process. Assuming the buyer is eligible because they have no visible criminal record or appear trustworthy is a dangerous and legally unsound practice. The FFL holder's personal assessment is not a substitute for the federally mandated background check. The Brady Act is designed to identify individuals who may not be outwardly prohibited, but are legally barred from firearm ownership due to factors not immediately apparent. This approach ignores the core purpose of the background check system. Professional reasoning. Professionals in this situation should follow a clear decision-making framework. 1. Initiate the NICS check for every firearm transfer. 2. Carefully review the NICS response. 3. If the response is a delay, immediately halt the transfer and await further instruction from NICS. 4. If the response is an approved, proceed with the transfer. 5. If the response is a denied, do not transfer the firearm and follow any further reporting requirements as stipulated by federal regulations. 6. Never rely on personal judgment or informal inquiries to override the NICS process. Question 3. The monitoring system demonstrates a discrepancy between the recorded acquisition and disposition of firearms and the physical inventory at a federal firearms license, FFL, holder's establishment in Texas. A specific handgun acquired 6 months ago is unaccounted for in the physical inventory, and its disposition has not been recorded. What is the most appropriate immediate action for the FFL holder to take? Option A. Wait for the next scheduled inventory audit to investigate the discrepancy, assuming the firearm may have been misplaced and will be found. Option B. Create a retroactive entry in the acquisition and disposition records to reflect the sale of the missing handgun, even without definitive proof of such a sale. Option C. Conduct a comprehensive internal audit of all acquisition and disposition records and physical inventory, and if the firearm remains unaccounted for, immediately initiate the ATF's reporting procedure for lost or stolen firearms. Option D. Disregard the discrepancy, assuming it is a minor clerical error that will likely be rectified during future audits without formal reporting. The correct answer is C. Conduct a comprehensive internal audit of all acquisition and disposition records and physical inventory, and if the firearm remains unaccounted for, immediately initiate the ATF's reporting procedure for lost or stolen firearms. Explanation. This scenario presents a professional challenge due to the inherent responsibility of a federal firearms licensee, FFL, to maintain accurate records and comply with federal law, specifically the Gun Control Act of 1968, as enforced by the Bureau of Alcohol, Tobacco, Firearms and Explosives, ATF. The FFL holder must balance efficient business operations with stringent regulatory requirements designed to prevent firearms from falling into the wrong hands. The core of the challenge lies in ensuring that all firearm transactions are properly documented and that any discrepancies are addressed promptly and in accordance with legal mandates. The best professional approach involves immediately initiating a thorough internal audit of the firearm inventory and transaction records upon discovering the discrepancy. This proactive measure demonstrates a commitment to regulatory compliance and responsible firearm stewardship. Specifically, the FFL should meticulously review acquisition and disposition, A&D, records, compare them against physical inventory, and identify any missing firearms or unrecorded transfers. If a firearm is confirmed missing, the FFL must then follow the specific ATF procedures for reporting lost or stolen firearms, which typically involves submitting ATF Form 3310-11 within a defined time frame. This approach directly addresses the regulatory requirement to account for all firearms and to report any loss or theft, thereby mitigating potential legal repercussions and contributing to public safety. An incorrect approach would be to delay reporting the missing firearm, hoping it will be found during routine inventory checks without formally notifying the ATF. This failure to adhere to the reporting timelines outlined in federal regulations constitutes a serious violation. Another incorrect approach is to attempt to cover up the discrepancy by falsifying records or creating a retroactive entry to account for the missing firearm. This constitutes fraud and carries severe penalties, including license revocation and criminal prosecution. Furthermore, simply assuming the firearm was sold without proper documentation and failing to investigate or report it is also unacceptable, as it bypasses the legal requirement for accurate record keeping and the reporting of all transfers. Professionals should employ a decision-making framework that prioritizes immediate compliance and transparency. Upon identifying a potential regulatory issue, the first step is to gather all relevant facts through a thorough internal review. The next step is to consult the specific regulations applicable to the situation, in this case, ATF regulations concerning firearm inventory and reporting. Finally, the professional must take decisive action that aligns with both the letter and the spirit of the law, which in this instance means prompt and accurate reporting to the ATF. The correct answer is A. The FFL holder must ensure the ATF Form 4473 is fully and accurately completed by both the buyer and the seller, and all required identification is verified before the buyer takes possession of the handgun. Explanation. This scenario is professionally challenging because it requires an FFL holder to balance their business operations with strict adherence to federal firearms regulations, specifically concerning the transfer of firearms and the accurate maintenance of records. The core of the challenge lies in ensuring that every transaction complies with the Gun Control Act of 1968, GCA, and its implementing regulations, particularly 27 CFR Part 178, while also managing customer expectations and business efficiency. A failure to meticulously follow these regulations can lead to severe penalties, including license revocation. The correct approach involves prioritizing the thorough completion and verification of the ATF Form 4473 before relinquishing possession of the firearm to the buyer. This aligns directly with the requirements of 27 CFR Section 178, 124, which mandates that the transferor, the FFL holder, must complete the form with the transferee, the buyer, and ensure all required information is provided and accurate. The FFL holder's responsibility is to verify the buyer's identity and ensure they are not prohibited from possessing firearms, which is facilitated by the completed Form 4473. This process is the cornerstone of lawful firearm transfers and prevents firearms from falling into the wrong hands. An incorrect approach that involves allowing the buyer to take possession of the firearm before the Form 4473 is fully and accurately completed presents a significant regulatory failure. This bypasses the critical verification steps mandated by the GCA, potentially allowing a prohibited person to acquire a firearm. It also compromises the integrity of the FFL holder's records, which are subject to ATF inspection. Another incorrect approach, which is to rely solely on the buyer's verbal assurance that they are not prohibited from owning a firearm, is also a direct violation of federal law. The GCA requires a documented process, the ATF Form 4473, to confirm the buyer's eligibility. Verbal assurances are not a substitute for this legally mandated record-keeping and verification procedure. Finally, an approach that involves completing the Form 4473 at a later date, after the buyer has already taken possession, is equally problematic. The law requires the form to be completed at the time of the transfer. Delaying this process undermines the purpose of the form as a contemporaneous record of the transaction and the buyer's eligibility at the point of sale. Professionals should employ a decision-making framework that emphasizes a compliance-first mindset. This involves understanding that regulatory requirements are not optional, but are integral to the lawful operation of an FFL business. When faced with a situation involving a firearm transfer, the immediate priority should be to consult and strictly follow the procedures outlined in the ATF Form 4473 and its accompanying instructions. This includes ensuring the buyer is of legal age, providing valid identification, and completing all sections of the form accurately before the firearm leaves the FFL's inventory. If any doubt or ambiguity arises, the professional should err on the side of caution and consult ATF guidance or legal counsel rather than proceeding with a potentially non-compliant transfer. Question 5. The monitoring system demonstrates that a customer in Texas has purchased one handgun from your Federal Firearms License, FFL, dealership and is currently in the process of selecting a second handgun with the intention of completing the purchase within the next 3 business days. Based on federal regulations governing FFLs, what is the most appropriate immediate action to take regarding reporting requirements? Option A. Only report the sale if the customer exhibits behavior that raises suspicion of a straw purchase. Option B. Immediately initiate the process to complete and submit ATF Form 3310-4 for the multiple handgun sale. Option C. Ask the customer if the second handgun is for personal use and only report if they indicate otherwise. Option D. Wait until the customer has taken possession of both handguns before considering any reporting. The correct answer is B. Immediately initiate the process to complete and submit ATF Form 3310-4 for the multiple handgun sale. Explanation. Scenario analysis. This scenario presents a professional challenge due to the inherent tension between maintaining efficient business operations and adhering to strict federal regulations designed to prevent firearms from falling into the wrong hands. The FFL holder must exercise meticulous judgment to balance these competing interests, ensuring compliance without unduly hindering legitimate commerce. The specific challenge lies in interpreting and applying the multiple sales reporting requirement, which is designed to flag potential straw purchases and understanding the nuances of when a sale triggers this obligation. Correct approach analysis. The best professional practice involves a proactive and thorough approach to identifying and reporting multiple sales of handguns within the specified time frame. This means that upon learning of the customer's intent to purchase a second handgun within 5 business days, the FFL holder should immediately initiate the process of completing and submitting the required ATF Form 3310. 4. This approach is correct because it directly aligns with the regulatory intent of the Gun Control Act of 1968, specifically 18 U.S.C. Section 923G3, and its implementing regulations, 27 CFR Section 478, 125E, which mandate the reporting of multiple handgun sales to the same purchaser within 5 business days. This ensures timely notification to law enforcement, aiding in the detection of illegal acquisition patterns. Incorrect approach is analysis. One incorrect approach is to delay reporting until the customer has physically taken possession of both handguns. This is a regulatory failure because the law requires reporting based on the *sale* or *disposition* of the firearms, not solely on their physical transfer. Delaying the report undermines the purpose of the regulation, which is to provide law enforcement with timely intelligence. Another incorrect approach is to assume that if the customer claims the second handgun is for personal use, the reporting requirement is waived. This is an ethical and regulatory failure. The FFL holder's responsibility is to report the multiple sale as required by law, regardless of the stated intent of the purchaser. The determination of whether a straw purchase has occurred is the purview of law enforcement, not the FFL holder. A third incorrect approach is to only report if the customer appears suspicious. This is a significant regulatory and ethical lapse. The multiple sales reporting requirement is a bright-line rule triggered by the number of handguns sold to the same individual within the specified period, not by subjective assessments of the customer's demeanor or intent. Relying on suspicion alone would lead to inconsistent and non-compliant reporting. Professional reasoning. Professionals in this field must adopt a decision-making framework that prioritizes strict adherence to regulatory mandates. This involves understanding the specific triggers for reporting requirements, such as the multiple handgun sale provision. When faced with a situation that potentially triggers a reporting obligation, the professional should err on the side of caution and compliance. This means consulting the relevant federal regulations, 18 U.S.C. Section 923G3 and 27 CFR Section 478, 125E, and if necessary, seeking guidance from the Bureau of Alcohol, Tobacco, Firearms, and Explosives (ATF). The decision-making process should be documented, demonstrating due diligence and a commitment to lawful operation. Question 6. Process analysis reveals that a federal firearms licensee, FFL, in Texas is presented with an offer to purchase a handgun from an individual who claims to be a resident of Oklahoma but wishes to complete the transaction in the FFL's Texas store. The individual presents a valid Oklahoma driver's license. What is the most compliant and professionally responsible course of action for the Texas FFL? Option A. Complete the transfer in Texas, accepting the Oklahoma driver's license as proof of residency, and advise the buyer to register the firearm in Oklahoma after taking possession. Option B. Refuse the sale outright, stating that Texas FFLs cannot sell handguns to non-residents under any circumstances. Option C. Verify the buyer's Oklahoma residency using their Oklahoma driver's license and complete the transfer in Texas, provided all federal background check requirements are met and no Texas state prohibitions apply to the buyer. Option D. Accept the Oklahoma driver's license as proof of residency and complete the transfer in Texas, assuming the buyer's intent to use the firearm in Texas negates the need for interstate transfer protocols. The correct answer is C. Verify the buyer's Oklahoma residency using their Oklahoma driver's license and complete the transfer in Texas, provided all federal background check requirements are met and no Texas state prohibitions apply to the buyer. Explanation. Scenario analysis. This scenario presents a professional challenge for a federal firearms licensee, FFL, in Texas due to the complex interplay between federal firearms regulations and state-specific laws regarding the transfer of firearms to individuals who are not residents of Texas. The FFL must navigate the requirements of the Gun Control Act of 1968, GCA, as amended, and any relevant Texas statutes to ensure compliance and avoid illegal straw purchases or prohibited transfers. The core challenge lies in accurately determining the buyer's state of residence and ensuring the transfer adheres to the laws of both the buyer's and seller's states, as well as federal law. Correct approach analysis. The best professional practice involves verifying the buyer's Texas residency through acceptable documentation and completing the transfer in accordance with federal law and Texas law. This means ensuring the buyer is a Texas resident, completing the ATF Form 4473 accurately, and conducting the required background check. If the buyer is not a Texas resident, the FFL must comply with the federal law that generally requires firearms to be transferred to an FFL in the buyer's state of residence, who will then complete the transfer according to their state's laws. This approach prioritizes adherence to the GCA's interstate transfer provisions and Texas's specific residency requirements for firearm purchases. Incorrect approaches analysis. One incorrect approach is to assume that because the sale is occurring in Texas, Texas residency is not a factor for a non-resident buyer. This fails to recognize that federal law dictates that a firearm must be shipped to an FFL in the buyer's state of residence for transfer, if the buyer is not a resident of the state where the sale is initiated. This can lead to illegal interstate transfers. Another incorrect approach is to accept a Texas driver's license as proof of residency for a buyer who explicitly states they live in another state. A Texas driver's license only proves residency within Texas. If the buyer is not a Texas resident, accepting this as the sole proof for a Texas-based transfer would violate federal regulations concerning interstate firearm sales. A third incorrect approach is to proceed with the sale without verifying the buyer's residency status, relying solely on the buyer's verbal assertion of their intent to use the firearm in Texas. This bypasses the critical step of establishing legal residency for the transfer, which is a cornerstone of federal firearms law and can facilitate prohibited transfers. Professional reasoning. Professionals in this situation should employ a decision-making framework that prioritizes legal compliance and ethical conduct. This involves 1. Clearly identifying the legal jurisdiction governing the transaction, federal and state. 2. Thoroughly understanding the specific requirements of the Gun Control Act of 1968 regarding interstate transfers and residency. 3. Verifying buyer residency through official documentation. 4. Consulting state-specific laws, such as those in Texas, that may impose additional requirements. 5. If there is any ambiguity or the transaction involves interstate elements, erring on the side of caution by adhering to the strictest interpretation of federal law, which often means requiring the transfer to occur in the buyer's state of residence. Question 7. The monitoring system demonstrates that a Texas-based federal firearms license, FFL, holder has received a request from local law enforcement to temporarily surrender a specific firearm from their inventory for investigative purposes, without a warrant. What is the most appropriate course of action for the FFL holder to ensure compliance with federal regulations and assist law enforcement? Option A. Surrender the firearm to law enforcement and assume they will handle the necessary record keeping. Option B. Refuse to provide the firearm to law enforcement, citing federal record-keeping requirements as an absolute barrier. Option C. Immediately contact the Bureau of Alcohol, Tobacco, Firearms, and Explosives, ATF, to seek guidance on how to proceed with the law enforcement request while maintaining accurate records. Option D. Provide the firearm to local law enforcement as requested, and then create a record of the transfer after the fact. Correct answer is C. Immediately contact the Bureau of Alcohol, Tobacco, Firearms, and Explosives, ATF, to seek guidance on how to proceed with the law enforcement request while maintaining accurate records. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires an FFL holder in Texas to balance the immediate need to comply with a law enforcement request with the overarching federal requirement to maintain accurate records and prevent diversion of firearms. The FFL holder must act swiftly, but also ensure their actions do not inadvertently compromise the integrity of their records or violate federal regulations. The potential for misuse of firearms and the legal ramifications for noncompliance necessitate careful judgment. Correct approach analysis. The best professional practice involves immediately contacting the ATF and seeking guidance on how to proceed with the law enforcement request while adhering to federal record-keeping requirements. This approach is correct because it prioritizes compliance with federal law 18 U.S.C. Section 923G and 27 CFR Section 478, 125, which mandates accurate and complete records of all firearm transactions. By involving the ATF, the FFL holder ensures that any action taken is sanctioned and documented, thereby protecting themselves from potential violations and assisting law enforcement in a legally sound manner. This proactive communication demonstrates a commitment to both public safety and regulatory adherence. Incorrect approaches analysis, providing the requested firearm to law enforcement without first consulting the ATF or ensuring proper documentation would be an ethical and regulatory failure. This bypasses the federal requirement for recording the transfer, potentially creating a gap in the chain of custody and violating 27 CFR Section 478, 125. It also risks the firearm being improperly transferred or used, which could lead to severe penalties for the FFL holder. Attempting to create a retroactive record of the transfer after the fact, without explicit ATF approval or guidance, is also a violation. Federal regulations require that records be made at the time of the transaction. Fabricating or backdating records is a serious offense that can lead to license revocation and criminal charges. Refusing to cooperate with law enforcement entirely, without offering to work with the ATF to find a compliant solution, could be seen as obstructing an investigation and demonstrates a lack of commitment to public safety, even if the FFL holder is concerned about their own record keeping. While federal regulations are paramount, a complete refusal without seeking a compliant path forward is not the most professional or ethical response. Professional reasoning. Professionals in this situation should employ a decision-making framework that prioritizes regulatory compliance and ethical conduct. This involves 1. Recognizing the immediate request and its potential implications. 2. Consulting relevant federal regulations, ATF guidelines, 18 U.S.C. Section 923G, 27 CFR Section 478, 125. 3. Proactively contacting the governing federal agency ATF for clarification and guidance. 4. Documenting all communications and actions taken. 5. Ensuring all subsequent steps align with federal requirements and law enforcement's legitimate needs. Question 8. Quality control measures reveal that a customer purchasing a handgun at your licensed firearms dealership in Texas has received a delayed status from the National Instant Criminal Background Check System, NICS, after completing ATF Form 4473. What is the most appropriate and legally compliant course of action? Option A. Contact the local Texas Department of Public Safety for guidance on how to proceed with the sale. Option B. Suspend the sale and immediately contact the ATF's National Tracing Center for a delayed background check, adhering to the 3-business-day waiting period before proceeding if no denial is received. Option C. Proceed with the sale immediately, as the delayed status does not constitute a denial. Option D. Discard the ATF Form 4473 and inform the customer that the sale cannot be completed without further explanation. The correct answer is B. Suspend the sale and immediately contact the ATF's National Tracing Center for a delayed background check, adhering to the 3-business-day waiting period before proceeding if no denial is received. Explanation. Scenario analysis. This scenario is professionally challenging because it involves a potential violation of federal firearms regulations, specifically concerning the transfer of a firearm to a prohibited person. The FFL holder has a legal and ethical obligation to ensure all firearm sales comply with the Gun Control Act of 1968, GCA, as enforced by the Bureau of Alcohol, Tobacco, Firearms, and Explosives ATF. Failure to do so can result in severe penalties, including license revocation, fines, and criminal prosecution. The FFL holder must exercise due diligence and make a sound judgment based on the information available at the point of sale. Correct approach analysis. The correct approach involves immediately suspending the sale and contacting the ATF's National Tracing Center, NTC, for a delayed background check. This aligns with ATF regulations and best practices for FFL holders. The ATF Form 4473, which the buyer completes, is the primary document for initiating a background check through the National Instant Criminal Background Check System, NICS. If NICS provides a delayed status, The FFL holder is legally permitted to proceed with the sale only after a waiting period of 3 business days, excluding weekends and holidays, has passed, and the ATF has not issued a denial. If the ATF has not made a final determination after 3 business days, the FFL holder may proceed with the sale, but must continue to monitor for any subsequent denial from the ATF. This approach prioritizes compliance with federal law and prevents the transfer of firearms to individuals who may be prohibited from owning them, thereby upholding public safety and the integrity of the FFL system. Incorrect approaches analysis. Proceeding with the sale immediately after the delayed status is an incorrect approach because it bypasses the ATF's opportunity to complete a thorough background check. The delayed status indicates that NICS could not immediately approve or deny the transaction, necessitating further review by the ATF. Completing the sale without this review violates the spirit and letter of the GCA, which mandates that FFLs ensure a firearm is not transferred to a prohibited person. Contacting the local police department instead of the ATF's NTC is also incorrect. While local law enforcement plays a role in public safety, the authority and responsibility for background checks and firearm transfer approvals under federal law rests with the ATF and NICS. Local police do not have the mandate or the system access to conduct the necessary federal background check. Destroying the ATF Form 4473 and refusing to sell the firearm without further inquiry is an incorrect approach because it does not follow the established federal procedure for handling delayed NICS checks. While the intention might be to avoid a potential violation, it fails to adhere to the regulatory framework that provides a specific process for delayed sales. The correct procedure is to await the ATF's determination or the expiration of the waiting period under specific conditions, not to unilaterally terminate the transaction without following the prescribed steps. Professional reasoning. Professionals in this field must adopt a decision-making framework that prioritizes regulatory compliance and ethical responsibility. This involves 1. Understanding the specific federal regulations governing firearm sales, particularly the GCA and ATF procedures. 2. Recognizing the significance of each status provided by NICS approved, denied, delayed. 3. Knowing the precise steps to take for each NICS status, including the waiting periods and notification requirements for delayed transactions. 4. Maintaining accurate and complete records, such as the ATF Form 4473. 5. Prioritizing public safety and the legal transfer of firearms above all else. 6. Seeking clarification or guidance from the ATF when uncertain about procedures. Question 9. The monitoring system demonstrates a pattern of firearm sales where the Federal Firearms Licensee, FFL, in California has been expediting transactions for customers who appear to be law-abiding citizens, often by performing only a visual inspection of their identification and bypassing the formal background check process for repeat buyers. Based on federal regulations governing firearm sales in the United States, which of the following represents the most appropriate and legally compliant course of action for the FFL? Option A. Continue expediting sales for known customers, but ensure that their identification is visually verified and that a note is made in the transaction log indicating their repeat buyer status. Option B. Inform customers that while a background check is generally required, exceptions can be made for individuals who can provide a valid California hunting license or a concealed carry permit as proof of eligibility. Option C. Immediately cease all expedited sales and implement a strict policy of conducting a full National Instant Criminal Background Check (NICS) for every firearm transfer, regardless of the customer's perceived trustworthiness or purchase history, and meticulously document each transaction according to federal guidelines. Option D. Focus on maintaining accurate inventory records and assume that customers who have purchased firearms previously are still eligible to do so, without requiring a new background check for each transaction. The correct answer is C. Immediately cease all expedited sales and implement a strict policy of conducting a full National Instant Criminal Background Check (NICS) for every firearm transfer, regardless of the customer's perceived trustworthiness or purchase history, and meticulously document each transaction according to federal guidelines. Explanation. Scenario analysis. This scenario presents a professional challenge due to the inherent tension between efficient business operations and the stringent regulatory requirements governing the transfer of firearms. A Federal Firearms Licensee, FFL, must balance the need to process sales quickly with the absolute mandate to verify the identity and eligibility of every transferee. Failure to adhere to these regulations can result in severe penalties, including license revocation and criminal charges. The challenge lies in identifying and mitigating risks of diversion or illegal acquisition without unduly burdening legitimate customers. Correct approach analysis. The best professional practice involves a proactive and meticulous approach to record keeping and verification, directly aligning with the core principles of the Gun Control Act of 1968, 18 U.S.C. Chapter 44, and its implementing regulations, specifically 27 CFR Part 178. This approach requires the FFL to maintain accurate and complete records of all firearm transactions, including the transferee's identification and the firearm's serial number. Crucially, it mandates that the FFL conduct a thorough background check through the National Instant Criminal Background Check System, NICS, for every sale, ensuring the transferee is not a prohibited person. This diligent adherence to established procedures is the bedrock of responsible FFL operation and legal compliance in the United States. Incorrect approaches analysis. One incorrect approach involves relying solely on a customer's verbal assurance of eligibility and a cursory glance at their identification. This fails to meet the legal requirement for a formal background check via NICS, leaving the FFL vulnerable to facilitating illegal transfers and violating 27 CFR Section 178. 102. Such a practice demonstrates a disregard for the law and a significant ethical lapse. Another incorrect approach is to expedite the sale by skipping the NICS check for repeat customers or those who appear trustworthy. This is a direct violation of 18 U.S.C. Section 922T and 27 CFR Section 178. 102, which mandate a check for every transfer. The perceived trustworthiness of a customer does not negate the legal obligation to verify their eligibility. A third incorrect approach is to maintain incomplete or inaccurate transaction records, such as omitting serial numbers or failing to record the full name and address of the transferee. This contravenes the record-keeping requirements outlined in 27 CFR Section 178, 125, which are essential for tracing firearms and ensuring accountability. Inaccurate records hinder investigations and demonstrate a lack of due diligence. Professional reasoning. Professionals in this field must adopt a decision-making framework that prioritizes legal compliance and ethical responsibility above all else. This involves understanding the specific requirements of the Gun Control Act and its associated regulations. When faced with a transaction, the framework should include 1. Verifying the transferee's identity with a government-issued photo ID. 2. Initiating a NICS background check for every sale. 3. Accurately and completely documenting all transaction details in accordance with 27 CFR Part 178. 4. Regularly reviewing internal procedures to ensure ongoing compliance. This systematic approach minimizes risk and upholds the integrity of the firearm transfer process. Question 10. The efficiency study reveals that a federal firearms licensee, FFL, in Texas has been experiencing significant delays in its annual inventory reconciliation process. The FFL's acquisition records show a total of 500 firearms acquired over the past year, and their disposition records indicate 485 firearms sold or otherwise transferred. However, a physical count of the current inventory reveals only 490 firearms on hand. To assess the severity of the inventory discrepancy and report it accurately to the Bureau of Alcohol, Tobacco, Firearms and Explosives (ATF), as required by 27 CFR Section 178. 125. F. The FFL must calculate the discrepancy ratio. What is the discrepancy ratio, expressed as a percentage? Based on the provided data, option A, the discrepancy ratio is 1.00% calculated as \frac 1,500 1,490 times 100 \. Option B, the discrepancy ratio is 1.00% calculated as \frac 1,500 1,485 1,500 times 100 \. Option C, the discrepancy ratio is 1.00% calculated as \frac 1,500 1,480 1,500 times 100 \. Option D, the discrepancy ratio is 0. 33%, calculated as backslash frac 1,500 1,490 1,500 backslash times 100 backslash. The correct answer is B. The discrepancy ratio is 1,00%, calculated as backslash frac 1,500 1,485 1,500 backslash times 100 backslash. Explanation. The efficiency study reveals a critical need to reevaluate inventory management practices for a federal firearms licensee, FFL, operating in Texas. The challenge lies in balancing regulatory compliance with operational efficiency, particularly concerning the accurate tracking of firearms. The scenario is professionally challenging because miscalculations in inventory can lead to significant penalties, including license revocation, and can also impact business profitability. A meticulous approach is required to ensure adherence to the Gun Control Act of 1968, GCA, and its implementing regulations, specifically 27 CFR Part 178, which mandates accurate record-keeping for all firearm acquisitions and dispositions. The best professional practice involves a systematic reconciliation of physical inventory against acquisition and disposition records, using a defined formula to identify discrepancies. This approach ensures that all firearms are accounted for, aligning with the legal requirement to maintain an accurate firearms transaction record. Specifically, the calculation of the discrepancy ratio, as the absolute difference between the total number of firearms recorded as acquired and the total number of firearms recorded as disposed, divided by the total number of firearms acquired, and then multiplied by 100 to express as a percentage, provides a clear metric for identifying the scale of any inventory issues. This method directly addresses the regulatory mandate for accurate record keeping by quantifying the deviation from expected inventory levels. An incorrect approach would be to simply estimate the number of missing firearms based on a general review of transaction logs, without performing a precise reconciliation. This fails to meet the stringent record-keeping requirements of the GCA, which demands exact figures, not approximations. Another incorrect approach is to focus solely on the number of firearms disposed of without cross-referencing it against the acquisition records, as this ignores the fundamental requirement to account for every firearm that enters and leaves the licensee's possession. Finally, an approach that prioritizes immediate sales over accurate record reconciliation, assuming that any discrepancies will be minor and can be addressed later, is ethically and legally unsound. It demonstrates a disregard for the law and a failure to uphold the responsibilities associated with holding an FFL. Professionals should employ a decision-making framework that prioritizes regulatory compliance as the foundational element of all operational decisions. This involves understanding the specific requirements of the GCA and 27 CFR Part 178, implementing robust internal controls, and conducting regular, precise audits. When faced with potential discrepancies, the immediate and accurate quantification of the issue, as demonstrated by the correct approach, is paramount. This allows for informed corrective actions and minimizes the risk of severe regulatory penalties. Question 11. Strategic planning requires a federal firearms licensee, FFL, in Texas to assess the implications of a newly proposed state law that may impose additional requirements on firearm sales beyond existing federal regulations. Which course of action best ensures the FFL's continued compliance and operational integrity? Option A. Halt all firearm inventory acquisition and sales until the proposed Texas state law is definitively enacted and its full implications are understood, even if this causes significant business disruption. Option B. Proactively research the proposed Texas state legislation, consult with legal counsel specializing in firearms law, and implement any necessary operational changes to comply with both federal and state requirements before acquiring new inventory. Option C. Rely solely on the existing federal regulations administered by the ATF for compliance, disregarding the proposed Texas state law as it is not yet finalized. Option D. Proceed with acquiring the new firearm inventory as planned, assuming federal regulations are the only binding requirements, and that the proposed state law will not be enacted or will be less stringent. The correct answer is B. Proactively research the proposed Texas state legislation, consult with legal counsel specializing in firearms law, and implement any necessary operational changes to comply with both federal and state requirements before acquiring new inventory. Explanation: strategic planning requires careful consideration of evolving regulatory landscapes and potential business impacts. In this scenario, a federal firearms licensee, FFL, in Texas, faces a critical decision regarding the acquisition of a new inventory of firearms that may be subject to new state-level regulations. The professional challenge lies in balancing the immediate business need for inventory with the imperative to comply with all applicable laws, avoiding potential penalties, and maintaining a reputable business. The FFL must navigate the complexities of federal firearm laws administered by the Bureau of Alcohol, Tobacco, Firearms, and Explosives, ATF, alongside any newly enacted or proposed Texas state laws that could affect the sale and transfer of firearms. The best approach involves proactively seeking clarification and ensuring full compliance with all identified regulatory requirements before proceeding with the acquisition. This means meticulously reviewing the proposed Texas state legislation, comparing it against existing federal regulations, and consulting with legal counsel specializing in firearms law. If the new state law imposes additional requirements beyond federal law, such as specific waiting periods, enhanced background checks, or restrictions on certain types of firearms, the FFL must implement procedures to meet these new obligations. This proactive stance demonstrates a commitment to legal and ethical business practices, safeguarding the FFL from potential violations, fines, and reputational damage. It also ensures that the business operations remain aligned with the law, preventing costly disruptions or the need for retrospective corrective actions. An approach that involves proceeding with the acquisition without fully understanding or adhering to the new Texas state regulations is professionally unacceptable. This could lead to violations of state law, resulting in penalties, license suspension, or even revocation by the ATF or state authorities. Another unacceptable approach is to assume that federal regulations are sufficient and ignore the new state law, as state laws can impose stricter requirements than federal ones. This demonstrates a disregard for the legal framework governing firearm sales within Texas. Furthermore, delaying the decision indefinitely or hoping the law changes without taking any concrete steps to understand its implications also represents a failure in professional judgment, as it leaves the business vulnerable to non-compliance and potential legal entanglements. Professionals in this situation should employ a decision-making framework that prioritizes legal compliance and risk mitigation. This involves 1. Identifying all relevant federal and state regulations. 2. Conducting a thorough comparative analysis of these regulations. 3. Seeking expert legal advice to interpret any ambiguities or new requirements. 4. Developing and implementing operational procedures to ensure compliance. 5. Documenting all compliance efforts. This systematic process ensures that business decisions are informed by a comprehensive understanding of the legal landscape, thereby protecting the business and upholding ethical standards. Question 12. Strategic planning requires an FFL in Texas to ensure compliance with federal firearm regulations. A new business practice is being considered that involves a streamlined process for verifying customer information during firearm transfers, which may deviate slightly from the most literal interpretation of certain ATF guidance documents. What is the most prudent course of action for the FFL to ensure continued compliance with federal law? Option A. Proceed with the new practice, assuming that minor deviations from ATF guidance are acceptable as long as the spirit of the law is maintained. Option B. Rely on the advice of legal counsel specializing in general business law, without specific expertise in federal firearms regulations. Option C. Implement the new practice based on the understanding that it is more efficient and commonly used by other FFLs in the region. Option D. Directly contact the ATF to seek clarification on the proposed business practice and its compliance with federal regulations before implementation. The correct answer is D. Directly contact the ATF to seek clarification on the proposed business practice and its compliance with federal regulations before implementation. Explanation: strategic planning requires careful consideration of evolving regulatory landscapes and operational best practices. This scenario presents a professional challenge for a federal firearms licensee, FFL, in Texas, due to the complex interplay between federal firearm regulations and state-specific business practices. The FFL must navigate the requirements of the Bureau of Alcohol, Tobacco, Firearms, and Explosives, ATF, while ensuring their business operations are compliant and ethically sound, particularly concerning the transfer of firearms and the maintenance of accurate records. The core challenge lies in balancing efficient business operations with the stringent legal obligations imposed by federal law. The best approach involves proactively seeking clarification from the ATF regarding any perceived ambiguities in federal regulations as they apply to the specific operational context. This demonstrates a commitment to compliance and a responsible approach to firearm sales. By directly engaging with the regulatory authority, the FFL ensures that their interpretation and implementation of federal laws, such as those governing the acquisition and disposition records at Form 4473, are accurate and up-to-date. This proactive stance minimizes the risk of violations and upholds the integrity of the firearm transfer process. An incorrect approach would be to rely solely on informal interpretations or the practices of other businesses. This risks misinterpreting federal law, leading to potential violations of the Gun Control Act of 1968 and its associated regulations. For instance, failing to properly document a firearm transfer or accepting an incomplete ATF Form 4473 could result in significant penalties, including license revocation. Another incorrect approach is to assume that a practice is acceptable simply because it is common within the industry, without verifying its compliance with federal mandates. This overlooks the fact that industry norms do not supersede legal requirements. Professionals should employ a decision-making framework that prioritizes understanding and adherence to the law. This involves 1. Identifying the relevant federal regulations, e.g., 27 CFR Part 178. 2. Assessing how these regulations apply to specific business operations. 3. If ambiguities exist, seeking official guidance from the ATF. 4. Implementing policies and procedures that strictly align with federal requirements. 5. Regularly reviewing and updating these policies to reflect any changes in law or guidance. Question 13. Strategic planning requires an FFL in California to consider how to manage a firearm transfer for a customer who claims to be a law enforcement officer and wishes to expedite the process, presenting a badge but no official identification that clearly matches the name on the firearm purchase paperwork. What is the most appropriate course of action for the FFL? Option A. Proceed with the transfer after verifying the customer's law enforcement status through an official law enforcement database or by contacting their agency and ensuring the ATF Form 4473 is completed accurately with all required information. Option B. Inform the customer that the transfer cannot proceed without a valid government-issued photo identification that matches the name on the purchase paperwork, regardless of their claimed profession. Option C. Contact the customer's purported agency to confirm their employment and eligibility, but proceed with the transfer if the agency confirms their status, even if the identification presented does not perfectly match the form. Option D. Complete the transfer immediately based on the presented badge, assuming the individual is who they claim to be and is eligible to receive the firearm. The correct answer is A. Proceed with the transfer after verifying the customer's law enforcement status through an official law enforcement database or by contacting their agency and ensuring the ATF Form 4473 is completed accurately with all required information. Explanation. Strategic planning requires careful consideration of regulatory compliance and ethical conduct, especially when navigating the complexities of federal firearms regulations. This scenario presents a professional challenge because it involves a potential conflict between business expediency and strict adherence to the Gun Control Act of 1968, GCA. As enforced by the Bureau of Alcohol, Tobacco, Firearms, and Explosives, ATF, in the United States, the licensee must balance the desire to facilitate a sale with the absolute requirement to verify the identity and eligibility of the transferee. Failure to do so can result in severe penalties, including license revocation and criminal charges. The best approach involves meticulously following the established procedures for firearm transfers. This means ensuring that the transferee completes the ATF Form 4473 accurately, and that the licensee conducts a thorough background check through the National Instant Criminal Background Check System, NICS, before transferring the firearm. The licensee must also verify the transferee's identification against the information provided on the form, ensuring it is valid and matches the individual presenting it. This diligent adherence to the GCA's transfer requirements is the only legally and ethically sound method for an FFL to transfer a firearm, preventing firearms from falling into prohibited hands. An approach that relies solely on the transferee's word regarding their eligibility or assumes their identity based on a casual acquaintance is a significant regulatory and ethical failure. GCA places the burden of due diligence squarely on the FFL. Accepting a firearm transfer without completing the required background check and verifying the transferee's identity is a direct violation of federal law. Similarly, transferring a firearm based on a perceived familiarity with the individual without the formal verification process bypasses critical safeguards designed to prevent illegal firearm acquisition. This demonstrates a disregard for the legal responsibilities of an FFL and the public safety implications of such actions. Professionals should employ a decision-making framework that prioritizes regulatory compliance and ethical responsibility above all else. This involves understanding the specific requirements of the GCA and ATF regulations, maintaining a comprehensive knowledge of these rules, and consistently applying them to every transaction. When faced with a situation that might tempt a shortcut, professionals should ask, does this action fully comply with federal law and ATF guidelines? And does this action uphold my ethical obligation to public safety? If the answer to either question is uncertain or negative, the transaction should not proceed until full compliance is achieved. Question 14. Market research demonstrates a growing demand for firearms in Texas, prompting a federal firearms licensee, FFL, to consider expanding their inventory and sales operations. During a single business week, the FFL sells 2 distinct handguns to the same unlicensed individual on separate occasions, with the second sale occurring 3 days after the first. Additionally, on a separate transaction within the same week, the FFL sells 3 rifles to a different unlicensed individual. The FFL is unsure about their reporting obligations to the Bureau of Alcohol, Tobacco, Firearms, and Explosives, ATF, for these transactions. What is the most appropriate course of action for the FFL regarding these sales? Option A. Do not report either transaction to the ATF, assuming that individual sales to unlicensed persons do not require reporting unless they involve a large quantity of firearms. Option B. Only report the sale of the 3 rifles to the ATF, as the sale of 2 handguns does not meet the threshold for mandatory reporting. Option C. Report the sale of the 2 handguns to the ATF, but delay reporting the sale of the 3 rifles until the following business week. Option D. Report both the sale of the 2 handguns and the sale of the 3 rifles to the ATF within 5 business days of the respective transactions. The correct answer is D. Report both the sale of the 2 handguns and the sale of the 3 rifles to the ATF within 5 business days of the respective transactions. Explanation. This scenario presents a professional challenge due to the inherent tension between a licensee's desire to expand their business and the stringent regulatory requirements designed to prevent illegal firearms trafficking and ensure public safety. A federal firearms licensee, FFL, in Texas must navigate these requirements with utmost diligence, as any misstep can lead to severe penalties, including license revocation and criminal charges. The core of the challenge lies in accurately identifying and reporting all transactions, especially those involving multiple firearms, while adhering to the specific reporting thresholds and timelines mandated by federal law. The best professional approach involves meticulously documenting and reporting all firearm sales that meet or exceed the reporting threshold within the specified timeframe. This includes understanding that the sale of 2 or more handguns or any number of long guns to the same unlicensed individual within a 5 business day period triggers a reporting requirement to the Bureau of Alcohol, Tobacco, Firearms, and Explosives, ATF. This approach is correct because it directly aligns with the requirements of the Gun Control Act of 1968, specifically 18 U.S.C. Section 923, and its implementing regulations, 27 CFR Part 178, which mandate that FFLs maintain records of all firearm transactions and report multiple handgun sales. By proactively and accurately reporting these transactions, the licensee demonstrates compliance and contributes to law enforcement's ability to track firearms. An incorrect approach would be to only report sales that involve more than 2 handguns, or to delay reporting until after the initial 5-business-day period has passed. The former fails to recognize that the sale of 2 handguns within the specified time frame is reportable, not just sales exceeding that number. The latter violates the explicit reporting deadline, undermining the purpose of timely intelligence for law enforcement. Another incorrect approach would be to assume that sales to a known, repeat customer do not require the same level of scrutiny or reporting as sales to a new customer. Federal regulations apply to all sales to unlicensed individuals, regardless of prior transaction history, and failing to report based on customer familiarity is a direct violation. These failures represent a disregard for the specific legal obligations of an FFL, potentially enabling illicit firearm acquisition and jeopardizing public safety. Professionals should employ a decision-making framework that prioritizes understanding and adherence to all applicable federal regulations. This involves regular training on ATF reporting requirements, maintaining up-to-date knowledge of any changes in regulations, and implementing robust internal record-keeping systems. When faced with a transaction that might trigger a reporting requirement, the professional should err on the side of caution, consult the relevant regulations, and ensure timely and accurate reporting. A proactive compliance mindset, rather than a reactive one, is crucial for maintaining an FFL and operating ethically and legally. Question 15. Stakeholder feedback indicates that some federal firearms licensees, FFL, in California are experiencing confusion regarding the proper procedure for verifying a buyer's eligibility to purchase a handgun, particularly when the buyer presents a California driver's license and claims to be a lawful resident. What is the most appropriate and legally compliant course of action for an FFL in California to ensure adherence to federal firearms laws? Option A. Accept the buyer's California driver's license as sufficient proof of identity and eligibility, and proceed with the sale without further checks. Option B. Complete the sale if the buyer possesses a valid California concealed carry weapon (CCW) permit, assuming this exempts them from the federal background check requirement for all handgun purchases. Option C. Rely on the buyer's verbal assurance that they are legally permitted to own a firearm and complete the transaction based on their statement. Option D. Obtain the buyer's personal information, accurately complete ATF Form 4473, and conduct a National Instant Criminal Background Check System (NICS) check through the designated state or federal portal. The correct answer is D. Obtain the buyer's personal information, accurately complete ATF Form 4473, and conduct a National Instant Criminal Background Check System (NICS) check through the designated state or federal portal. Explanation. This scenario presents a professional challenge due to the inherent tension between a licensee's obligation to comply with federal firearms regulations and the desire to facilitate legitimate business operations. The licensee must exercise careful judgment to ensure that all transactions are conducted in strict accordance with the Brady Handgun Violence Prevention Act and its implementing regulations, particularly concerning the verification of a buyer's eligibility. The core of the challenge lies in balancing efficiency with the paramount importance of preventing firearms from falling into prohibited hands. The correct approach involves meticulously adhering to the prescribed procedures for verifying a buyer's identity and eligibility to purchase a firearm. This includes obtaining the required personal information from the prospective buyer, completing the ATF Form 4473 accurately, and conducting the National Instant Criminal Background Check System (NICS) check. If the NICS check results in a proceed status, the licensee can then complete the sale. This method is correct because it directly implements the statutory requirements of the Brady Act and ATF regulations, which are designed to prevent firearms sales to individuals prohibited by law. It ensures that the licensee has taken all reasonable steps to confirm the buyer's eligibility before transferring a firearm, thereby fulfilling their legal and ethical obligations. An incorrect approach would be to proceed with the sale based solely on a buyer's assertion of eligibility or the presentation of a state-issued identification that does not inherently confirm federal firearm purchase eligibility. This fails to meet the statutory requirement of conducting a NICS check, which is the primary mechanism for determining if a buyer is prohibited from owning a firearm under federal law. Ethically, this bypasses a critical safeguard designed to enhance public safety. Another incorrect approach would be to rely on a buyer's possession of a state-issued permit to carry a concealed handgun as a blanket exemption from the NICS check requirement for all firearm purchases. While some states may have provisions for alternative procedures for permit holders, federal law mandates a NICS check, unless specifically exempted by federal regulation or a state's alternative procedure approved by the Attorney General. Failing to conduct the required check, even with a carry permit, constitutes a regulatory violation. A further incorrect approach would be to complete the sale after receiving a delayed status from the NICS check, without waiting for the mandatory waiting period to expire or for a proceed determination. A delayed status indicates that the NICS system requires further review, and the sale cannot be completed until the delay period concludes with a proceed, or the buyer is determined to be eligible. Proceeding during a delay period circumvents the investigative process and risks transferring a firearm to a potentially prohibited individual. Professionals should employ a decision-making framework that prioritizes strict adherence to regulatory requirements. This involves understanding the specific obligations under the Brady Act and ATF regulations, maintaining up-to-date knowledge of NICS procedures and any state-specific variations, and implementing robust internal compliance protocols. When faced with ambiguity or a situation that deviates from standard procedure, the professional should err on the side of caution, consult relevant ATF guidance, and if necessary, delay or refuse the sale to ensure full compliance and uphold public safety. Question 16. The evaluation methodology shows that a federal firearms licensee, FFL, in Texas is processing a firearm sale. The purchaser presents a Texas driver's license that has been expired for 6 months and states they have recently moved, and their new address is not yet reflected on the license. The purchaser also offers a utility bill with their current address. What is the most appropriate course of action for the FFL to take in accordance with federal firearms regulations? Option A. Proceed with the sale, accepting the expired driver's license and the utility bill as sufficient proof of identity and residency. Option B. Accept the expired driver's license and note the new address verbally from the purchaser on the ATF Form 4473. Option C. Accept a photocopy of the purchaser's valid, unexpired driver's license along with the utility bill. Option D. Decline the sale, explaining that the presented identification is expired and the address discrepancy cannot be resolved with the provided documentation according to federal guidelines. The correct answer is D. Decline the sale, explaining that the presented identification is expired and the address discrepancy cannot be resolved with the provided documentation according to federal guidelines. Explanation. The evaluation methodology shows that this scenario is professionally challenging due to the inherent conflict between a licensee's desire to facilitate a sale and their strict legal obligation to verify the identity and eligibility of a firearm purchaser. The complexity arises from the need to balance customer service with the paramount importance of adhering to federal firearms laws, specifically the Gun Control Act of 1968, as enforced by the Bureau of Alcohol, Tobacco, Firearms and Explosives (ATF) in the United States. A failure to properly identify and verify a purchaser can lead to severe penalties, including license revocation and criminal charges, and more importantly, the potential diversion of firearms to prohibited individuals. The correct approach involves meticulously following the procedures outlined in ATF regulations for verifying purchaser identification. This includes examining a valid government-issued identification document that contains the purchaser's photograph, date of birth, and address, and ensuring that the information presented on the identification matches the information provided on the ATF Form 4473. Furthermore, the licensee must ensure the identification is not expired and appears to be authentic. This rigorous adherence to identification verification protocols is mandated by federal law to prevent firearms from falling into the wrong hands and is the cornerstone of responsible firearm sales. An incorrect approach that involves accepting a driver's license that is expired by several months and has a significantly different address than the one provided on the Form 4473 represents a direct violation of ATF identification verification requirements. Federal regulations require that identification be valid and current. Accepting such documentation demonstrates a disregard for the legal mandate to confirm the purchaser's identity and residency, thereby increasing the risk of a straw purchase or sale to a prohibited person. Another incorrect approach, which is to rely solely on the purchaser's verbal assurance of their identity and eligibility without proper documentation, is fundamentally flawed and legally untenable. Federal law explicitly requires the examination of a valid government-issued identification. Verbal assurances do not meet this legal standard and expose the licensee to significant liability. Finally, an approach that involves accepting a photocopy of a driver's license, even if the original is claimed to be at home, is also unacceptable. ATF regulations require the physical examination of the original identification document. Photocopies are not considered valid forms of identification for the purpose of firearm sales, as they can be easily altered and do not provide the same level of authenticity verification as an original document. The professional reasoning process in such situations should prioritize legal compliance above all else. Licensees must be trained to recognize valid identification and understand the specific requirements for each piece of information on the ATF Form 4473. When in doubt about the authenticity or validity of an identification document, the licensee should err on the side of caution and refuse the sale, or seek clarification from the ATF. Building a culture of strict adherence to these regulations is essential for maintaining a federal firearms license and ensuring public safety. Question 17. Regulatory review indicates a federal firearms licensee, FFL, operating in Texas has been approached by two individuals who wish to conduct a private firearm transfer of a handgun. One individual is the current owner, and the other is the prospective buyer. Both individuals are Texas residents and claim the transfer is a private sale between them, not involving any commercial aspect beyond the FFL's premises. The FFL is considering facilitating this transfer. What is the most appropriate course of action for the FFL to ensure compliance with federal firearm regulations? Option A. Inform the individuals that since it is a private transfer between Texas residents, the FFL has no obligation to be involved or conduct any checks. Option B. Facilitate the transfer without a background check, as Texas law permits private handgun sales between residents without a background check. Option C. Conduct a federal background check for the prospective buyer through the National Instant Criminal Background Check System, NICS, before facilitating the transfer. Option D. Advise the individuals to complete the transfer outside the FFL's business premises to avoid federal requirements. The correct answer is C. Conduct a federal background check for the prospective buyer through the National Instant Criminal Background Check System, NICS, before facilitating the transfer. Explanation. Scenario analysis. This scenario presents a professional challenge for a federal firearms licensee, FFL, in Texas due to the complex interplay between federal regulations governing firearm sales and state-specific laws regarding private firearm transfers. The FFL must navigate the requirement to conduct background checks for all sales, including those that might appear to be private transfers facilitated through their business, while also respecting the privacy and rights of individuals engaging in lawful firearm ownership. Misinterpreting the scope of federal law or the FFL's role in facilitating transfers can lead to violations of the Gun Control Act of 1968, GCA, and potentially Texas state laws. Correct approach analysis. The best professional practice is to treat any firearm transfer facilitated by the FFL, regardless of the parties involved, as a sale requiring a federal background check through the National Instant Criminal Background Check System, NICS. This approach aligns with the ATF's guidance that an FFL cannot act as a mere conduit for private transfers without conducting a background check. By adhering to this, the FFL ensures compliance with 18 U.S.C. Section 922T, which mandates background checks for all firearm sales by licensed dealers. This proactive stance prevents potential violations and upholds the integrity of the firearm transfer process. Incorrect approaches analysis. Facilitating the transfer without a background check, assuming it's a private sale between two Texas residents, is a direct violation of federal law. The GCA does not exempt FFLs from conducting background checks simply because the transaction occurs within a state that permits private firearm sales without a background check. FFL's involvement transforms the transaction into a sale by a licensed dealer. Suggesting the individuals complete the transfer outside the FFL's premises to avoid the background check requirement is also a serious regulatory failure. This circumvents federal law and demonstrates a lack of commitment to compliance, potentially exposing the FFL to severe penalties. It also implies an intent to evade legal obligations, advising the individuals that Texas law allows private transfers without background checks, and therefore the FFL is not obligated to intervene, while partially true for purely private transactions, is incorrect when the FFL is involved in facilitating the transfer. The FFL's role as a licensed dealer supersedes the nuances of state private transfer laws in this context. Professional reasoning. Professionals in this situation should adopt a risk-averse and compliance-focused mindset. The primary decision-making framework should be: does this action comply with federal firearm laws, specifically the Gun Control Act of 1968 and ATF regulations, as interpreted for FFLs? When in doubt, err on the side of caution and consult official ATF guidance or legal counsel. The FFL's license is a privilege, and maintaining it requires strict adherence to all applicable laws, prioritizing federal mandates over perceived state-level conveniences or interpretations. Question 18. Performance analysis shows that a federal firearms licensee, FFL, operating in Texas has received an online order from a customer residing in California. The customer wishes to purchase a handgun that is legal to own and possess in Texas. The FFL has confirmed the customer's eligibility to purchase a handgun under federal law through a NICS background check. What is the most compliant and professionally responsible course of action for the Texas FFL to ensure the legal transfer of the firearm to the California resident? Option A. Ship the handgun directly to the California resident's home address after confirming their eligibility via a federal background check and ensuring the handgun is legal in Texas. Option B. Ship the handgun to a federal firearms licensee in California, who will then complete the transfer to the resident in accordance with California state laws and regulations. Option C. Ship the handgun directly to the California resident's home address, provided the FFL obtains a written affidavit from the resident stating the handgun is legal to possess in California. Option D. Proceed with the sale and transfer the handgun directly to the California resident at the Texas FFL's place of business, as the sale is legal in Texas. The correct answer is A. Ship the handgun directly to the California resident's home address after confirming their eligibility via a federal background check and ensuring the handgun is legal in Texas. Explanation. Scenario analysis. This scenario presents a professional challenge for a federal firearms licensee, FFL, in Texas due to the complex interplay between federal firearms regulations and state-specific laws regarding the transfer of firearms to out-of-state residents. The FFL must navigate the requirements of the Gun Control Act of 1968 GCA, specifically 18 U.S.C. Section 922, A.3 and B.3, which govern interstate firearm sales, while also being aware of any Texas-specific statutes that might impose additional or conflicting requirements. The core challenge lies in ensuring compliance with the laws of the state in which the recipient resides at the time of sale, which can be a nuanced area, especially when dealing with online sales and potential variations in state laws. Failure to adhere to these regulations can result in severe penalties, including license revocation and criminal prosecution. Correct approach analysis. The best professional practice involves verifying that the firearm is being transferred in compliance with the laws of the state where the recipient resides. This means the FFL must ensure that the sale and transfer would be legal in the recipient's home state, even if it is also legal in Texas. Specifically, this requires the FFL to confirm that the recipient is legally permitted to own the firearm in their state of residence, and that the firearm itself is legal for possession in that state. For an out-of-state sale, the firearm must be shipped to a federal firearms licensee in the recipient's state of residence, and the transfer must be completed in accordance with that state's laws, including any background check requirements mandated by that state. This approach directly aligns with the federal requirement that an FFL shall not knowingly sell or deliver any firearm to any person in any other state, except to a licensee of such state. Incorrect approaches analysis. One incorrect approach is to assume that if the sale is legal in Texas, it is permissible to transfer the firearm to an out-of-state resident. This fails to acknowledge the federal mandate that the laws of the recipient's state of residence must be satisfied. This approach risks violating 18 U.S.C. Section 922(a)(3) and (b)(3), which explicitly require compliance with the laws of the state where the recipient resides. Another incorrect approach is to only conduct a federal background check, e.g., NICS, without verifying the legality of the specific firearm or the recipient's eligibility under their state's laws. While a federal background check is a necessary component, it does not supersede the requirement to comply with the recipient's state laws regarding firearm types and possession eligibility. This approach overlooks potential state-specific prohibitions or restrictions that are not covered by the federal NICS system. A third incorrect approach is to ship the firearm directly to the out-of-state resident's home address without involving a licensed dealer in their state. This is a direct violation of federal law, which mandates that firearms sold or shipped to out-of-state residents must be transferred through a licensee in the recipient's state of residence. This bypasses the recipient state's regulatory framework for firearm transfers. Professional reasoning. Professionals in this situation must adopt a proactive and diligent approach to compliance. The decision-making process should begin with identifying the recipient's state of residence. Next, the FFL must thoroughly research and understand the firearm laws of that specific state, including any restrictions on firearm types, waiting periods, or additional background check requirements. If the sale involves shipping, the FFL must arrange for the firearm to be sent to a licensed dealer in the recipient's state, who will then complete the transfer according to their state's laws. This layered approach ensures that all federal and state legal requirements are met, mitigating the risk of legal repercussions and upholding ethical responsibilities. Question 19. The control framework reveals that a federal firearms licensee, FFL in Texas, is processing a firearm sale. The buyer presents a valid Texas driver's license, but the address listed on the license is 6 months old. The buyer also appears to be purchasing a handgun that is commonly used for self-defense, and the buyer's demeanor is unusually nervous. The FFL dealer must decide how to proceed with this transaction, considering their obligations under federal firearms regulations. Option A. Complete the ATF Form 4473 with the address from the buyer's driver's license, despite it being outdated, and advise the buyer to update their address with the state later. Option B. Proceed with the sale after confirming the buyer passes the NICS check, assuming the outdated address is a minor issue and the buyer's nervousness is unrelated to the transaction. Option C. Refuse the sale. Document the reason for refusal as a potential straw purchase or failure to provide current, accurate information on ATF Form 4473 and report the incident to the ATF. Option D. Complete the sale, but make a note in the dealer's private records that the buyer's address was outdated and they seemed nervous without further action or reporting. The correct answer is C. Refuse the sale. Document the reason for refusal as a potential straw purchase or failure to provide current, accurate information on ATF Form 4473 and report the incident to the ATF. Explanation. The control framework reveals a scenario that is professionally challenging due to the inherent tension between facilitating legitimate commerce in firearms and preventing their diversion to illegal channels. The complexity arises from the need to balance federal regulatory compliance with the practical realities of business operations and the ethical imperative to uphold public safety. Firearms dealer must exercise meticulous judgment to ensure all transactions adhere strictly to the Gun Control Act of 1968, GCA, and its implementing regulations, particularly concerning the transfer of firearms and the accurate completion of ATF Form 4473. The best professional practice involves a rigorous adherence to the established federal regulatory framework for firearm sales. This approach prioritizes the accurate and complete documentation of every firearm transfer, including thorough verification of the buyer's eligibility through the National Instant Criminal Background Check System, NICS, and the meticulous completion of ATF Form 4473. Specifically, the dealer must ensure that the buyer's identification is valid and that all information provided on the form is truthful and accurate. Any discrepancies or red flags, such as a buyer attempting to purchase a firearm for another individual, straw purchase, must be immediately identified and the sale refused. This aligns directly with the GCA's intent to prevent firearms from falling into the hands of prohibited persons and to maintain a record of firearm transfers. An incorrect approach would be to overlook minor discrepancies on the ATF Form 4473, such as a slightly outdated address on a buyer's identification, with the assumption that the buyer is otherwise legitimate. This failure to ensure the absolute accuracy and currency of all information on the form is a direct violation of federal regulations, which mandate precise data entry. Such an oversight could inadvertently facilitate a straw purchase or a transfer to a prohibited person, undermining the GCA's objectives and exposing the dealer to severe penalties, including license revocation and criminal charges. Another professionally unacceptable approach is to proceed with a firearm sale when the dealer has a reasonable suspicion that the buyer is acquiring the firearm for someone else, even if the buyer passes the NICS check. The GCA places a responsibility on FFL holders to be vigilant and to refuse sales that appear to be straw purchases, regardless of the NICS outcome. Failing to act on such suspicions is a critical ethical and regulatory failure, as it directly contributes to the illegal diversion of firearms. Finally, a flawed approach involves prioritizing sales volume over diligent compliance. This might manifest as rushing through the paperwork or accepting incomplete information to expedite transactions. This attitude disregards the fundamental purpose of the FFL and the GCA, which is to ensure responsible firearm commerce. Such a lax approach creates significant legal and ethical risks, as it increases the likelihood of errors and omissions that could have severe consequences for public safety and the dealer's business. Professionals in this field must adopt a decision-making process that begins with a thorough understanding of all applicable federal laws and regulations. This includes regular training and updates on ATF guidelines. When presented with a transaction, the dealer must systematically verify the buyer's identity and eligibility, meticulously complete all required documentation, and remain vigilant for any indicators of prohibited activity or straw purchases. If any doubt or suspicion arises, the dealer must err on the side of caution, refuse the sale, and report the suspicious activity to the ATF. This proactive and diligent approach is essential for maintaining legal compliance and upholding ethical responsibilities. Question 20. Strategic planning requires a federal firearms licensee, FFL, in Texas to accurately calculate their federal excise tax liability for the previous quarter. During this quarter, the FFL sold 50 pistols at an average sale price of $600 each, 30 rifles at an average sale price of $800 each, and 100 boxes of ammunition at $20 per box. The FFL also sold 20 gun cleaning kits for $30 each, which are not subject to federal excise tax. What is the total federal excise tax liability for this quarter? Option A, $14,000. Option B, $12,000. Option C, $15,200. Option D, $13,000. The correct answer is C, $15,200. Explanation: scenario analysis. This scenario presents a professional challenge for a federal firearms licensee, FFL, in Texas due to the complex interplay between federal regulations governing firearm sales and the specific record-keeping requirements for certain types of firearms. The FFL must accurately calculate and report the excise tax liability, which directly impacts their financial obligations and compliance with the Bureau of Alcohol, Tobacco, Firearms and Explosives, ATF, regulations. Failure to correctly assess and remit this tax can lead to significant penalties, including fines and potential revocation of the FFL. The challenge lies in correctly identifying the taxable items, applying the appropriate tax rate, and ensuring the calculation is precise, especially when dealing with multiple firearm types and accessories. Correct approach analysis. The best professional practice involves a meticulous, item-by-item calculation of the federal excise tax based on the manufacturer's or importer's sale price of taxable firearms and ammunition. This approach directly adheres to the requirements of the Internal Revenue Code, IRC, and ATF regulations, specifically 26 U.S. Code Section 4181, which mandates a tax on the sale of pistols, revolvers, rifles, shotguns, and ammunition. For the FFL in Texas, this means identifying each taxable item sold, determining its sale price, and applying the correct tax rate, e.g., 10% for firearms, 11% for handguns, 11% for ammunition. The total tax liability is the sum of these individual calculations. This method ensures accuracy, transparency, and full compliance with federal tax laws. Incorrect approach is analysis. One incorrect approach is to apply a flat percentage to the total revenue from all firearm and ammunition sales, without differentiating between taxable and non-taxable items, or considering specific tax rates for different firearm types. This fails to comply with 26 U.S. Code Section 4181, which specifies distinct tax rates and applies only to certain categories of firearms and ammunition. It also ignores the possibility of non-taxable accessories being included in the total revenue. Another incorrect approach is to estimate the tax liability based on historical sales data without performing a current, detailed calculation for the specific reporting period. While historical data can inform projections, federal tax law requires precise reporting based on actual sales and prices during the reporting period. This method risks underpayment or overpayment of taxes, both of which can lead to penalties. A third incorrect approach is to only calculate the tax on the profit margin rather than the manufacturer's or importer's sale price. The IRC clearly defines the tax base as the sale price, not the profit. This fundamentally misunderstands the excise tax structure and would result in a significant underreporting of tax liability. Professional reasoning. Professionals in this situation should adopt a systematic and detail-oriented approach. First, they must thoroughly understand the specific federal excise tax laws applicable to firearms and ammunition sales, particularly 26 U.S. Code Section 4181. Second, they should maintain detailed sales records that clearly distinguish between taxable firearms, taxable ammunition, and any non-taxable accessories. Third, for each taxable item, they must identify the correct sale price and apply the corresponding tax rate. Finally, they should sum these individual tax calculations to arrive at the total excise tax liability for the reporting period. This methodical process ensures compliance, minimizes financial risk, and upholds professional integrity.